Thank you, Academy, for inviting me here. Thank you, team of my leader of my team, Professor Paweł Czubik, and thank you, my colleagues. I work with you. I would like to say a few words about principles of recognition of non-recognition of foreign civil judgments from the perspective of a Polish court. I have a PhD, I'm a doctor of law, I'm a Polish judge, so I have opportunity to deal with those instruments in my everyday judicial life. First, some remarks, introductory remarks about this topic. The issue of recognition of foreign civil judgments constitutes one of the classical yet continuously relevant problems of private international law. Its significance has markedly increased together with the intensification of cross-border legal relations, particularly in the sphere of commercial transactions, family matters, and property disputes. Today, national courts are increasingly faced with the necessity of assessing the legal effects of judgments rendered outside the borders of their own state. From the perspective of a Polish court, the recognition of a foreign judgment is not a simple technical activity, nor an act of international courtesy. It's a decision with far-reaching systemic consequences, consisting in admitting an act of foreign judicial authority into the domestic legal order. Such a decision must take into account both the requirements of international cooperation and the need to protect fundamental constitutional principles and procedural guarantees. The purpose of this presentation is to outline the principles governing the recognition and the grounds for refusal of recognition of foreign civil judgments from the point of view of a Polish court on the basis of the applicable normative framework and established lines of the case law. The concept and effects of recognition of a foreign judgment. Recognition of a foreign civil judgment means granting its legal effects within the territory of the Republic of Poland, equivalent to those produced by a judgment of a domestic court. Legal scholarship emphasizes the recognition primarily concerns substantive law and procedural effects, including the authority of res judicata and the prejudicial binding effect on subsequent proceedings. Under Polish law, a fundamental distinction exists between recognition and the declaration of enforceability. Recognition alone does not yet lead to the possibility of applying state coercive measures. It merely results in the integration of the effects of the judgment into the domestic legal order. Only a declaration of enforceability enables execution. From the perspective of a Polish court, it is essential that recognition does not involve re-examination of the case. The court does not become a court deciding on the merits, but limit itself to reviewing the conditions laid down by the legislature. So let's go to normative basis for the recognition of judgments in Polish law. First of all, Constitution. The system of recognition of foreign civil judgments in Poland is based on several fundamental normative regimes. This results from the diversity of legal sources applicable not only to different categories of cases, but also from the multiplicity of legal relationships arising from the international obligations of the Republic of Poland. Pursuant to Article 91 of the Constitution of the Republic of Poland, a ratified international agreement approved by statute shall have precedence over a statute if such statute cannot be reconciled with the agreement. Accordingly, a court must first examine whether there exists a bilateral or multilateral agreement between Poland and the state of origin of the judgment concerning mutual recognition of judgments or legal assistance in civil and commercial matters. In Polish doctrine, this is referred to as the principle of priority of international treaties. If such an agreement exists, the court applies its provisions by virtue of the systemic supremacy of international treaties. If no such agreement exists, the provisions of the Code of Civil Procedures are applied as the law of the forum state. In this way, the Code of Civil Procedure performs the function of a universal residual mechanism, ensuring the possibility of recognition a judgment even in relations with state with which Poland has not concluded any judicial cooperation agreement. Thus, where a foreign judgment has been rendered by a court, and in certain cases also by another authority issuing an act treated as a judicial decision, for example, notaries in specific categories of cases, and the decision has been issued in one of the EU member states, European Union law applies. In particular, this includes regulations governing judicial cooperation in civil and commercial matters, such as the Brussels I bis regulation, the Brussels II-ter regulation, and the succession regulation. These instruments are directly applicable and enjoy primacy. If the judgment originates from another state, it must be determined whether Poland is bound to that state by a bilateral or multilateral agreement, convention, governing legal cooperation and the mutual recognition of judgments. At the multilateral level, particular importance is attached to the Hague Conventions prepared by the Hague Conference on Private International Law. Although not all of them have been ratified by Poland, they perform an important model setting and interpretative function for the domestic provisions. From the perspective of recognition of civil and commercial judgments, the most important are in particular, and as you can see on the presentation, the Hague Convention of 1st February 1979 on the recognition and enforcement of foreign judgments in civil and commercial cases. The Hague, and this is classical instrument that influenced later European instruments, including Brussels Conventions and the Brussels I bis regulations. The second is the Hague Convention of 2005 on choice of court agreements, ratified by the European Union and binding upon Poland since 2022. And this convention provides for automatic recognition of judgments rendered by a court chosen in a jurisdiction clause agreed by the parties. And the third one is the Hague Convention of 2019 on the recognition and enforcement of foreign judgments in civil and commercial cases. An attempt to create a global regime for recognition of judgments in relation to EU member states, including Poland. It entered into force on 1st of September 2023 and applies in relations with states that are parties to it. So it's quite a new instrument. The Hague Conventions, particularly those of 2005 and 2019, represent a second generation of treaties, emphasizing automatic recognition and limited, exhaustively enumerated list of grounds for refusal. For states belonging to the European Free Trade Association, EFTA, namely Switzerland, Norway, Iceland, and Liechtenstein, The 2007 Lugano Convention applies. It is essentially a replica of the former Brussels I regulation, but retains the exequatur procedure, meaning that the judgment requires formal confirmation of enforceability. Poland, as an EU member state, is bound by this convention through ratification by the Union. In practice, this means that judgments, for example, from Swiss courts, are recognized in Poland almost automatically. The next examples are some examples of selected bilateral agreements. I chose 3 of them. The agreement between the Republic of Poland and the Russian Federation on legal assistance and legal relations in civil, family, and criminal matters from 1996, governing the recognition of an enforcement of Russian judgments in Poland and vice versa, providing for a simplified procedure. The agreement between the Republic of Poland and the Republic of Belarus of 1994, containing similar solutions based on mutual trust while allowing refusal on public policy grounds, and the agreement between the Polish People's Republic and the People's Republic of China of 1987, permitting recognition of enforcement in civil, family, and commercial matters, while providing for more extensive jurisdictional and formal control of the European system. As you can see, those are post-communist countries or even communist country. If we consider China as a communist country, the old name of Poland and China, like Polish People's Republic, because it was in the 80s, and it is still valid, and it's and we still use it in our court practice. Next thing. There is a principle of automatic recognition. Both EU law and the Polish domestic law currently adopt the principle of automatic recognition of foreign civil judgments. This principle is expressed in Article 1145 of the Code of Civil Procedure in force in Poland since 1st of July 2009. According to which judgment of courts of foreign states are recognized by operation of law unless grounds for refusal exist. A similar situation is adopted in EU law and in the Lugano Convention, which in many cases eliminate the need to initiate separate recognition proceedings. From the perspective of a Polish court, this means that the review of recognition is subsequent and incidental, activated only when an appropriate objection is raised. This model promotes procedural efficiency and the principle of effective judicial protection, while simultaneously limiting the scope of interference by the domestic court. For example, our Polish Supreme Court characterized this system currently in force in Poland in its decision of 7th February 2019, stating, following the amendments introduced by the Act of 5th December 2008, effective of 1st July 2009, pursuant to Article 1145 of the Code of Civil Procedure, judgments of courts of foreign states rendered in civil matters are recognized by operation of law, provided that no obstacles referred to Article 1146 of the Civil Procedure Code exist. This systemic solution corresponds to Article 21 of Council Regulation 2201/2003 concerning jurisdiction of and the recognition and enforcement of judgments in matrimonial matters and matters of parental responsibility, which assumes that a judgment rendered in one member state is recognized in other member states without the need for any special procedure. The adopted model of automatic recognition introduced significant facilitation and simplification of the requirements imposed on a foreign judgment. In order to avoid risk arising from different assessments of whether a particular judgment is subject to recognition when such assessment is made for the purposes of proceedings pending before various authorities, the legislature enabled any person having a legal interest in the recognition of a foreign judgment to apply to a court for the initiation of proceedings to determine whether the judgment of a foreign court is or is not subject to recognition. Article 1148 of the Code of Civil Procedure. This procedure gives effect to the assumptions of Article 21 of Regulation 2210/2003. And another very important thing is prohibition of review on the merits, révision au fond. It is one of the fundamental principles governing the recognition of foreign civil judgments, and it is about the prohibition of review on the merits. This principle has been firmly established both in doctrine and in the case law of the Supreme Court. The prohibition of substantive review means that the Polish court does not examine the correctness of the application of substantive law or the accuracy of factual findings made by the foreign court. The court is not entitled to substitute its own assessments for that one of the foreign court. As emphasized in the case law of the Supreme Court, recognition of a foreign judgment must not result in the creation of a hidden appellate instance. The prohibition of révision en fond follows from the principle of state sovereignty and the need to ensure stability of legal relations. And there are some grounds for refusal of recognition under Polish law. And as you can see, it's in the article of 1146, paragraph 1 of the Code of Civil Procedure. A judgment shall not be subject to recognition if it's not final in the state in which it was rendered. It was rendered in a matter falling within the exclusive jurisdiction of Polish courts. The defendant who did not enter an appearance was not duly served with the documents instituting the proceedings in time sufficient to enable a defense. A party was deprived of the opportunity to defend its rights in the course of the proceedings. Proceedings concerning the same claim between the same parties were pending in the Republic of Poland earlier than before the foreign court. It is contrary to an earlier final judgment of a Polish court or an earlier final decision of a foreign court meeting the conditions for recognition in the Republic of Poland, rendered in a case concerning the same claim between the same parties. And the last one, recognition would be contrary to the fundamental principles of the legal order of the Republic of Poland. Public policy clause. In practice, the most significant of these grounds are lack of jurisdiction of the foreign courts in matters falling within the exclusive jurisdiction of Polish court, infringement of the right of defense, incompatibility with the fundamental principles of the Polish legal order, lack of finality of the judgment, and existence of an earlier conflicting judgment. From the perspective of a Polish court, it is essential that these grounds are exceptional in nature and may not be interpreted expansively. The public policy clause plays a special role in the system of refusal of recognition. It is a classical instrument for the protection of the fundamental principles of the domestic legal order. In the case law of the Supreme Court, it is emphasized that incompatibility with public policy must be manifest and must concern a principle of fundamental importance, such as constitutional principles, basic individual rights, or elementary rules of procedural justice. The Supreme Court has repeatedly indicated that mere differences in legal solutions or even erroneous interpretation of foreign law does not justify application of the public policy clause. Its application should be absolutely exceptional. The right to a fair trial as a ground for refusal. One of the most frequently analyzed grounds for refusal of recognition is violation of the right to a fair trial. This ground is expressly provided for both in the Code of Civil Procedure and in instruments of the EU law. In this respect, the Polish court examines whether a party had a real opportunity to defend its right, whether it was properly notified of the proceedings, and whether it was able to present its position. Case law emphasizes that what is required in observance of minimum procedural standards, not full identity of procedures. In this context, the jurisprudence of the European Court of Human Rights is also of significance important as it sets standards arising from the right to a fair trial. Mutual trust in the European Union law. European Union law is founded on the principle of mutual trust between member states. This principle assumes that judicial systems of the member states provide an equivalent level of legal protection. The Court of Justice of the European Union has repeatedly emphasized that this principle limits the possibility of refusing recognition of judgments rendered in another member state. Refusal may occur only in exceptional situations where the violation of fundamental rights is manifest and serious. From the perspective of a Polish court, this necessitates particular restraint in applying grounds for refusal in cases governed by EU law. And the role of the Polish court as a reviewing authority. In proceeding concerning recognition of a foreign judgment, the Polish court acts as a reviewing authority rather than as a court deciding on the merit. Its task is to ensure that the effects of the foreign judgments are compatible with the fundamental principles binding in Poland. This role requires maintaining a balance between the effectiveness of international cooperation and the protection of the domestic legal order. The court may neither automatically accept all judgments nor excessively broaden the scope of its review. And the trends, developmental trends, contemporary trends in the recognition of foreign civil judgments point toward further liberalization and simplification of procedures. Increasing importance is attributed to the principle of mutual trust and the protection of fundamental rights. At the same time, the growing influence of the case law of European courts as a reference can be observed from the perspective of a Polish court. This entails an increasing need to take supranational standards into account. And going to the last part, the case law, few cases of Polish Supreme Court. The first one, partial recognition of a US damages judgment recognized with respect to actual damages and refused with respect to punitive damages. Supreme Court decision of 2003. There is a long-lasting discussion about punitive damages, as we should accept it in a continental system or not. Polish Supreme Court said no, it's against our view of compensation. The second interesting case, a US divorce judgment recognized as having been rendered under condition depriving the defendant of the possibility of defense. The Supreme Court held that the private substitute service accepted by a United States court affected on a person other than the defendant in divorce proceedings, even if formally valid under US law, must be independently assessed by a Polish court as to whether it ensured a real opportunity for defense. The third interesting case is a Danish judgment abolishing joint parental authority and awarding sole custody to the Danish father not subject to recognition in Poland. Polish Supreme Court decided in 2018, and the Supreme Court held that the enforcement of a Danish judgment abolishing joint parental authority and granting sole custody to the Danish father, where the child was 7 years old, had lived in Poland for 4 years under the exclusive care by the Polish mother, had forgotten the father, and where the stay in Denmark would be contrary to the child's welfare, and this would violate Polish public policy and therefore could not be recognized. And the last one, a judgment of a US bankruptcy court refused recognition as a contrary to the public policy clause, and Polish Supreme Court held that recognition of the effectiveness of a judgment of United States Bankruptcy Court discharging a bankrupt foreign debt would be contrary to the public policy where the debtor concealed substantial assets located in Poland in the US bankruptcy proceedings from which creditors could be satisfied, and where the debtor could not be regarded as insolvent under a Polish law. Conclusion. In conclusion, the principles governing the recognition and refusal of recognition of foreign civil judgments are based on a carefully balanced compromise between openness to foreign decisions and protection of the fundamental values of the domestic legal order. Operating within the realities of a globalized legal environment, Polish courts act as guardians of this balance. Recognition of a foreign judgment is not an act of relinquishing sovereignty, but rather its modern manifestation, a conscious admission of the effects of foreign judicial decisions into the domestic legal order, provided that its fundamental principles are respected. Thank you very much for listening, and sorry for my technical problems. Thank you.